Hello friends, in the series on the income tax cases, today we will discuss an issue which makes it very clear that the revenue department, especially the income tax department, has such a big appetite for litigation that if in any case the assessee gets the relief from the CIT appeal, then how negatively the revenue takes and fights that case without any basis to the utmost of their power just to increase the agony of the assessee. This issue has come in the case of Deputy Commissioner of Income Tax versus AP Net Fab. This matter has been reported in 109 ITAT Tribunal page number 492 and the matter has been decided by Chandigarh ITAT A bench and the date of the judgment is 21st November 2023. In the present case, the issue was related to the employee's contribution to the employee state insurance. The assessee has not deposited the employee share within the time allocated in those acts, but it was deposited before the due date. Assessing officer made the addition when the matter came to the CIT appeal, because when the decision was given by the CIT appeal, at that time the checkmate decision was not available. So based on the various judgments available at that time in favor of the assessee, the CIT appeal gave the relief. The revenue department filed appeal before the tribunal. The tribunal rejected the appeal on the basis of low tax effect. The revenue filed the miscellaneous application before the tribunal on the basis of para 10b of circular number 3 of 2018 that the limits for filing the appeal does not apply in a case where the virus of a circular or any circular instruction has been challenged. But in the present case, it was the plea of the assessee that CIT appeal has not recorded any finding about any circular which is being challenged. It was also the submission of the assessee that the CIT appeal does not have any jurisdiction to challenge the virus of any circular. But the revenue was contesting just on a very baseless thing, even though there was not any mention in the order of the CIT appeal that he has considered any circular for giving relief to the assessee, or during the appellate proceedings before the CIT appeal, the CIT appeal has referred any circular into his hearing or in the CIT appeal order. The tribunal said that the CIT appeal may not have followed the circular. It may happen, but there was nothing on record that such circular or any such circular has been brought to the notice of the CIT appeal. The tribunal also said that in the present case, however, not following the circular does not mean by any stretch of imagination to be challenging the virus of the circular. Friends, this is such a strange case that when the tribunal has rejected the appeal of the revenue on the basis of the low tax effect, the revenue is contesting the case on an issue which is not there at all into the CIT appeal order or the order of the assessment, but just bringing an issue to fight or to just promote the litigation. The revenue is contesting the matter. Even if the appeal has been rejected, the department is again filing the miscellaneous application just to increase the agony of the assessee. This is the fate of income tax litigation as on date. The CIT appeals do not have the time to dispose of the appeals of the assessee. Only those appeals are being disposed which are ex parte or which do have very low tax effects, where the assessees have given the submissions running into 30 or 40 pages. All those appeals are not being taken by them for the reasons best known to them. So in the present situation, when the appellate authorities do not have time to dispose of the appeals, if these type of miscellaneous applications or the appeals will be filed just on the baseless points, then it will lead to a very unlikely situation or very bad situation for the assessee, that he has to fight his cases for no basis. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus AP NITFAB. This case has been reported in 109 ITAT Tribunal, page number 492. The matter has been decided by Chandigarh ITAT A bench and the date of the judgment is 21st November 2023. Thank you friends.